the associated basin plan amendments, that's when we provided a great deal of clarifying information regarding the applicability of those effluent limits. As it was very broad brush, it was very wide open and not well defined. We felt when we adopted the TMDL that it was important to clarify the application of those limits. And specifically, as noted, those entities, the local governments and Caltrans who are under waste load allocations under the TMDL, those effluent limits do not apply to them from their discharges. And so we clarified the application of those limits from development and redevelopment projects that aren't subject to those more comprehensive load reduction planning efforts. So again, I think there's some selective reading of the basin plan going on here regarding where those effluent limits apply. Our understanding at this point is the basin plan as crafted provided us broad, loose, frankly, definition of when those do apply, and we narrowed that and better defined that as part of the TMDL process. Again, there were a lot of comments, so if there's any particular questions I can address, we've responded to most of the concerns raised in the response to comments.
Yeah, it's real.
I looked left first. I should.
No, it's okay. Sorry about no need to apologize. There was, or Mr. Lazeau mentioned the prospect that the State Water Board doesn't, now that we've approved the Tahoe TMDL, we can't come in and look at it. But, just last month we had the Los Angeles region come before us and update, a very comprehensive update of several TMDLs. And that was an opportunity for us to review the information. Could you remind us of the Region 6's intent in terms of the periodic review of the TMDL and notwithstanding that we would get executive officer and executive director's report on this TMDL of statewide significance, but isn't there some sort of commitment to review it and update it as necessary?
Yeah, the Lake Tahoe TMDL explicitly identifies the need for an adaptive management program. We've been fortunate in the Tahoe Basin to receive federal funds from the Southern Nevada Public Lands Management Act. A large grant from that program was awarded to us to develop a formalized TMDL management system, a formal adaptive management program to report out on TMDL progress, or to gather information on what's being done on the ground, gather relevant scientific monitoring information to relate what's being done on the ground to the actual water quality improvements, to disseminate that information, and to engage with stakeholders throughout the basin to determine whether there is a need for policy adjustment. As indicated, we do have a detailed implementation plan for the first 20 years. We know that's all we have, and so it is absolutely anticipated by the TMDL and explicitly mentioned in the TMDL Basin Plan Amendment that we do anticipate the need to revisit the TMDL, better understand whether or not the allocations are appropriate, whether or not our load estimates need adjusting, whether the implementation plan needs to be adjusted to reflect conditions on the ground. There's a whole suite of things that we will need to evaluate. And obviously, anytime we amend our basin plan, we will come before this board and bring those amendments before you for consideration. So, yeah, obviously there is ample opportunity for this board to maintain an ongoing engagement with the Lake Tahoe TMDL process.
And then one thing you noted in your presentation was there's also in the TMDL and then there, the 208 plan, some commitment to environmental restoration in addition to, when we talk about crediting programs, we think a lot about, treatment or infiltration and more of a defensive stance, but there's also a commitment to environmental restoration. Is there a linkage there with the TMDL in terms of, or in this adaptive implementation, we'll be seeing some attempts to quantify the benefits of such exercises?
Yeah, we have many explicitly defined programs to quantify the benefits from urban stormwater actions on the ground. You're right that the crediting program itself perhaps is a bit misleading to folks who haven't been involved. It does not allow offset because of the outstanding national resource water status of Lake Tahoe. Because our TMDL explicitly does not allow any increase of pollutant loading, the crediting program is not designed as an offset program. It's an accountability and tracking program for us. So again, we have very detailed quantitative tools to help us better understand what's happening in the urbanized areas, and that makes sense because roughly 3/4 of the pollutants reaching the lake are coming from the urbanized area. We are also working on a number of different projects to better understand the benefits of stream restoration projects and how those projects are influencing water quality. There's a great deal of atmospheric monitoring that has been ongoing to better understand the benefits and synergies between activities on the ground for urban stormwater and how that's influencing atmospheric deposition. And we're working closely with our forest partners as well to implement appropriate BMPs for vegetation management and restoration actions, and to, again, better understand how all those things are influencing water quality. The TMDL management system is intended, again, to bring all of this information together and help us as resource managers better understand how that information is guiding us for policy in the future.
No, I appreciate that, Mr. Larson. It's a very good technical response. And for my fellow board members, you know, one of the things that he just mentioned was the atmospheric deposition and how it influences urban runoff. You know, nowhere else in the state is there such a sensitive water body to what comes out the exhaust pipe. You know, the nitrogen emissions. Is this right, Mr. Larson? I mean, it can.
Yes.
It can make a signal in water quality.
Yeah, we definitely have done our best to quantify the direct atmospheric deposition onto the lake surface. And as you indicate, the tailpipes are the largest source of the nitrogen reaching the lake. That's why we've worked so closely with the TRPA and their transportation policies to better understand how the transportation policies can help us reduce the vehicle miles traveled to help address some of that nitrogen loading. Again, all of these things in the Tahoe Basin, you start tugging on the threads and everything's connected there.
Right. It's just, I find it fairly profound, you know, in terms of just how sensitive the lake is to those little, what we think are little inputs in places like, you know, the Bay Area or LA. So thank you, Mr. Larson.
I wanted to just briefly respond to the comments on the process. We have John Marshall here from TRPA, who I think will go into a little more detail in his comments on what's Chapter 10 that sets out when amendments would be made. And initially, the regional board did have some issues with automatic incorporation of changes, and we worked with TRPA, who then worked with Nevada and US EPA to come up with something that was a little more palatable, which essentially identifies, you know, keeps with that framework idea of we don't want to incorporate, as we did previously, the entire regional plan into the 208 plan, but instead have a framework that we're working from and identifying those parts of the regional plan where if there's changes and they're going to have a water quality impact, well, of course, we want a process to come back and have recertification, but we don't want to be in the position of where we were previously and not having anything done for many, many years because it was so burdensome and so difficult, and instead to set up a process that instead allows flexibility, allows changes to occur as we know more information, as science improves, and only when there's going to be really a change that's going to affect water quality to bring that back. And so that's what we're trying to do. And like I said, changes were made that made us more comfortable with how that process is going to work, and TRP, I hope, will comment a little more on that.
Great. Well, why don't we move to Mr. Marshall, and then we may come back.
Thank you, Madam Chair.
Mr. Marshall, Turpa General Counsel.
Not quite as tall as Mike. Thank you very much. My name is John Marshall, and I'm a General Counsel for the Tahoe Regional Planning Agency, and way back in 1989, I think, a intern at the Office of Chief Counsel for the Water Board.
Mr. Lawfer will now look up any reviews written of you.
Did you work on the first 208 plan?
No, unfortunately not. That was actually a little before my time. But I think what's critical here is for the basin partners, the 208 plan in front of you represents a kind of culmination of almost a change in attitude towards how environmental change and restoration can occur in the basin. What's critical about our regional plan, the regional plan update, is it kept in place the vast bulk of the regulatory system that protects Lake Tahoe. And what it tried to do was incentivize environmental restoration through redevelopment. And so a lot of the changes that are coming through, that came through with the amendments, had to do with trying to move development from outside urban centers inside to encourage and add flexibility and incentives inside those urban cores to allow the redevelopment to happen. And when redevelopment happens, let's take South Shore, for example. If you've been there at any time within the last 20 years, you see that a lot of the built environment was built back in the 50s, 60s, and 70s, not at a time when we had rigorous environmental regulations that we have in place and that remain in place when you have new construction. The BMPs you have to put in place, all sorts of requirements for how much you can build, the mitigation fees you have to pay. So anytime we get a project that rebuilds, we get environmental benefit. And so that's what this plan is trying to, an element of this plan is trying to do. I think a great example of why we are kind of shifting, most of the conversation here, I think, has to do with why are we shifting from a 208 plan that has a lot of regulatory language in it. You know, you shall do this, you shall do that, to more of a framework that your staff has described. And the reason for that is because I think a great example is our BMPs. The original 208 plan had a BMP manual attached to it. You know, one of the 7 volumes was the BMP manual, and almost immediately it was out of date because technology changes. And we need the flexibility to adopt and implement strategies without having to go through the incredibly difficult process through 2 states and the EPA of a 208 plan amendment. I think everyone agreed that we wanted to be more responsive than that. And so that's really the framework that I think a lot of the concerns of the Sierra Club and Friends of West Shore is this kind of feeling of angst that we're removing somehow the regulatory strictures that were in place. And what the 2 states did through the bi-state negotiation was try to figure out a way in which we can transition from the current plan, which has a lot of regulatory limitations, which precludes the basin players from really adopting quickly different kinds of strategies, to an era in which the 208 plan functions as this overall framework, and then each individual component of that overall plan can be updated without having to come to you all, without having going to Nevada, without having going to EPA every single time. So what Chapter 10 of the 208 plan does is it basically sets out a transition period for this kind of movement away from this kind of strict regulatory structure of the 208 plan to more of the planning framework, which is typically what, if there are any 208 plans that have been updated recently,
of a 208 plan.
To more typically what those are.
Right.
And the 2 states got together and tried to figure out a way in which what were the important critical elements of the regulatory scheme, and those kind of are incorporated by reference in Chapter 10, and then any amendments to those that have an adverse effect on water quality require 208 plan amendment. So that's kind of the structure and the reason why, how we're trying to transitioning from this kind of 7-volume 208 plan that was born at a time in which I think the states were very concerned about what was the existing regulatory system, but that has been in place now for 20 years and essentially remains in place over the next, or to continue with the new regional plan update. I'd be happy to answer any questions that you have.
Great, thanks.
Yeah.
Uh,
Go ahead.
Is it because we're dealing with 2 states that you think a 208 plan is useful, or have you considered, I mean, apparently they used to exist in lots of areas and they don't exist anymore. What do you see in terms of the value of a 208 plan?
I think the 208 plan is a valuable tool to kind of focus all the interests on what is the overarching plan for water quality in the Tahoe Basin. It is a nice document that wraps in the TMDL, the regional plan, the Forest Service plans, various elements so you can kind of, you know, I might have left my copy in my chair, but now in a fairly concise document, you have all the component elements. Thank you. I was just holding it up to show its thinness rather than actually having it. But you have all the component elements that put in one place kind of and summarize the strategies for water quality improvement in the basin. What it doesn't do is it moves away from specifying in there the exact mechanism by which those water quality benefits will be met, or the strategies that will be undertaken, like land use incentives or coverage limitations or the actual mechanics of the TMDL. So I think it still serves a function of kind of as in one place. You can go now to one place and you have reference all of these documents that allow you to see how the agencies within the basin are addressing water quality.
It's interesting because you touched on it in terms of its historical significance, you know, in the 80s. Would you say the 208 plans functioned then as sort of a safety net almost because of the certain programs to address specific pollutants weren't really as mature back in the 80s, and that maybe congressional intent was to have in these important areas of the country to have this important sort of floor or of protection, and now we feel more confident that we've you know, created more specificity on how to meet water quality standards. You know, there's some sort of so in other words, back then 208 was sort of a safety net. Today it's more of a, you know, a gathering function.
Yes.
Of all the other existing safety nets that now exist that didn't then.
Yes, I think that's a great characterization. I wouldn't say the 208 plan from, you know, from the federal legislative perspective was meant to operate as a, you know, really, you know, at the level of which our 208 plan had operated. I don't think that was the intent of the document. It was used that way by the parties back then to kind of, you know, provide a regulatory backstop. But I would say that for all the reasons that we've talked about today, that is no longer necessary, and all the basin players, with a few exceptions, I think agree that it's time to transition to something else. We don't want to do that immediately. We want to do that over, you know, a period of time to make certain that everything is working. But that's the general approach that the basin players have decided upon. Thank you very much.
Thank you. We may call you back. Next, I have Todd Ferrara, Deputy Secretary of Resources.
Good morning, board members. My name is Todd Ferrara. I'm Deputy Secretary for the California Natural Resources Agency. We support the adoption of the resolution as proposed by the staff. From our perspective at the Natural Resources Agency, we look at the 208 plan as an encouraging example of the renewed bi-state collaboration that's going on in the basin, led by, on our side, Secretary Laird for the administration, and in conjunction with all of our state partners. So I just want to conclude by saying we really want to thank the Lahontan and Water Board staff for their solid work and your consideration of this item. Thanks.
Thank you. Laurel Ames, Co-Chair, Tahoe Area Sierra Club.
Hi, you all. I am Laurel Ames, Tahoe Area Sierra Club, and I want to correct several misstatements here. One was the Lahontan said that they had no indication from us as to what our problems with the EIR are, and in fact, we sent them a copy of our brief challenging the EIS, excuse me. And we have endless problems with the EIS. I will cite one, and that is that we are told that the TRPA EIS covers the changes in land use that would come about with, for instance, the exemption for the large ski area on 250 to 300 acres of undeveloped land. But it doesn't. It's a very 30,000 square foot level height, looking down. It's broad, it's vague, there's hardly any change as relates to the ski area part of the exemption in today's 208 issue that addresses that construction, that project, that anything. It's not in there at all. And you can't even deduce that there might be an implication of it in the language in the EIS. The EIS that would have used that a section to deal with the ski area didn't change from April till October. The next issue is the ski area itself. That's really a big sticking point because the water quality impacts of construction of a ski area are pretty horrendous. You have 4-lane highway-sized ski runs that go downhill. Of course, that's what we do when we ski. And if you blade out fragile land 4 lanes wide, it takes a long time to re-veg it in the Tahoe Basin. We have a 60-day growing season, although it may increase with climate change. And then on top of that, you have raw land. You're putting on roads, hotels, condos, single-family homes, huge amounts of commercial, gondola, chairlifts. This goes in large maintenance facility. It goes on, and it's very disturbing to have it slipped into the plan. It never made it into the plan during the plan process or the bi-state process. This was slipped in afterwards in this late arriving 208 plan amendment and just got our attention in a big hurry. I want to also talk about, well, I want to mention the regional plan again, and that is next door to us is the Byron Share Room. And Byron Share was sitting on the board, the governing board of the TRPA, when this plan was adopted. And he raised very great concerns about the plan, about the EIS, and about the threshold standards, which is the piece in the compact, which we haven't talked about here, but that's where the bi-state compact mandates certain that certain standards be developed to protect the lake and the resources of the basin. And when Byron speaks with great authority, and he's very clear, and he's very lawyerly, and he was very, very impressive. And of course, all the locals and a couple of the state agency appointees voted for the plan, but Byron and another state agency assembly appointee voted against it. This was after an absolutely astounding PR campaign in support of it. The TRPA had 5 full-time PR people. There are other problems with the way the 208 plan is moving ahead and the exemptions, the 5-year exemptions. If you look at the Santa Monica stormwater ordinance, it really lays out how to deal with stormwater. They have their good housekeeping standards. They have all of these standards that are in an ordinance, a regulatory ordinance, which we've heard we want to be more flexible at Tahoe. But the Sierra Club doesn't want to be more flexible. We want to protect water quality. But none of those things that are in the Santa Monica ordinance about dealing with stormwater are in the TRPA ordinance. And here's another part of this, and that's pervious pavement. I'm sure you hear a lot about pervious pavement, and pavement can be pervious. The TRPA plan allows, I can't remember, 25% benefit for pervious pavement. Do they know if it works? No. Do they know if they are putting in the right kind? Has anybody tested it? You look at Seattle They have 5 pages on how to test and assure and measure and maintain pervious pavement. There's nothing like that in the TRPA plan. So these are all the reasons that we're very concerned with that 5-year exemption effort. And we just think that we need more time. We need to be able to work with Lahontan and the TRPA. We'd like to do that to figure this out. I mean, why was a ski area slipped in at the last minute? Well, we know. The Ski Area Corporation's attorney did it. It was very political. Had nothing to do with water quality. I think that's really enough. I can't answer questions. Oh, I did want to answer about adaptive management program. The adaptive management program, and I'm sure you're seeing this more and more, is an the agency program. It's not a science adaptive management program. And that's becoming more and more an issue with the agencies who would rather measure how many pounds of fine sediments they collected. But what does it mean? There's no measuring of that, because that's the science basis. So you can say, yes, this is wonderful. We collected X number of tons of fine sediments, but what? Where? Was it close to the lake? Was it clear up on the ridges? We don't know. I think one last point, the TRPA plan allows up to 100% coverage in certain coverage management plans. And the standard the threshold standard is 30%. But they would do this by moving around and consolidating the 100% in one place. Well, that could be a good idea. But the other 30%, because they still have to save 30% in this total area, which is the infiltration area, there's no discussion. Does the infiltration area go between this 100% coverage in the lake, or does it go above the 100% coverage in the lake? There's just no discussion of this in these plans at all. So we worry. And we are in the midst of a lawsuit, as you know. Thank you.
Thank you very much. Question, a couple things I'd like responded to that Ms. Ames left. The question of the level of precision or detail in the regs about, say, the comparison between the LA, this is in LA, the LA stormwater program, you can pick any similar thing you want, and what's in the TRPA plan. I'm presuming that under the TMDLs, you're going to get to a level of granularity that goes beyond that. Now, can you talk about that a little bit? Because, and I appreciate, Ms. Ames, your counsel start out by talking about the things you were worried about, which is a totally valid public policy concern. So to what extent can you allay her fears on this by where it would be, as opposed to being in the TRPA plan or the 208 plan, ultimately?
The political and regulatory landscape of the Tahoe Basin is complex. I think there are multiple layers of regulations that apply. The TMDL, the regional plan, are both large bi-state regional planning efforts that are at a pretty, as Ms. Ames indicated, at a pretty high level. They're regional plans. As you get down to local government regulation, we have the MPDS permits on the California side, which then get to a finer level of detail regarding expectations on local government and what they're required to do to achieve water quality standards. Within the MPDS program, of course, there is a requirement that the local government maintain legal authority to implement their programs, and implicit in that is to develop a stormwater ordinance, which each of the local governments on the California side of the California side of the Tahoe Basin have done. So there are detailed stormwater ordinances of the same detail and information that Ms. Ames references for the city of South Lake Tahoe, Placer County, and El Dorado County. So I guess looking for that information in the 208 plan is not the place to find it, and that level of detail and that level of specificity is at the local government regulation level where it actually matters to apply those things to the ground. Regarding sort of design standards and how local government is supposed to implement various BMPs or stormwater treatment measures, there are the TRPA BMP handbook provides, as Mr. Marshall indicated, a much more up-to-date and science-based document that provides a reference for appropriate mechanisms to reduce pollutant loading. We have in the Tahoe Basin probably some of the most sophisticated estimation tools that help us better understand urban hydrology and the interrelationship between maintenance practices, whether it's street sweeping, and then where water flows to different BMPs, and how all of those things work together to reduce pollutant loads in the basin. So I think the level of quantification and accountability that we have in the Tahoe Basin probably exceeds that in most other areas. I think a lot of areas in the state are probably quite envious of the science effort that we have in the Tahoe Basin. We have, a more than 40-year record of water quality parameters in the lake itself. To suggest that we're just counting particles or otherwise, looking at the loads discounts the ongoing direct water quality measurements of the lake and tributaries themselves, along with direct stormwater monitoring that is required by the NPDES permit and being implemented by a basin-wide consortium. So there's a great deal of science and a great deal of specificity at various levels where appropriate.
That was my understanding, having contributed to some of that back at in the old days when it was first coming together and I was at EPA.
I think Chair Marcus had the pleasure of going out on the UC Davis, the UC Davis vessel to see some of the water quality measurements that UC Davis takes on behalf of the TRPA and the Water Board on a regular basis. Again, that boat is on the water every week, measuring the transparency of the lake, measuring nutrient content at different levels in the lake, looking at the productivity of the lake's waters as it relates to different nutrient concentrations. There's a great deal of science and monitoring that goes on to, and the adaptive management program is intended to link that science, link that ongoing monitoring to our management and policy approaches.
Can you talk a little bit about this this ski project that Ms. Ames references? I'm presuming that it will go through or you can, Mr. Marshall, a classic EIR process at the local level that would get to the project level detail.
Yeah, I'll defer to Mr. Marshall on that.
Mr. Marshall has a big binder.
He always does.
I don't know why I have this binder. What Ms. Ames is, I think, referring to is there's a section in Chapter 10 that talks about, again, this is the section that talks about when two-way plan amendments are required. There is a requirement that if there is another resort recreation designation, that if there's one more, that won't require a two-way plan amendment. But if there's more than that, then it requires a two-way plan amendment. So that was through negotiations with the states as to when they thought they needed a two-way plan trigger for another resort recreation designation. Now, what is that?
Yeah.
And you can see how this gets directly down into hardcore land use planning, which is really, I think, not what two-way planning does well, but nonetheless, resort recreation district is a new land use category that TRPA developed to try to address in our objectives to kind of focus development in areas either within an urban core or within an area where people will get out of their cars. There are places in the basin, like the base of Heavenly on the California side, and right next to the casinos, there's another parcel that is very close to existing recreation facilities that might be the place to put some of our existing, not new, but existing development in the basin to get it out of places that we don't want it, and perhaps put it in places where people will get out of their cars and stay in one spot and reduce VMT, redevelop or develop under our existing ordinances. And so in the regional plan, TRPA approved 2 resort recreation districts. In fact, we defined it as only 2, okay? So if we want to add another one, we have to amend our entire regional plan to get another resort recreation district. So that requires all the things that go along with a regional plan amendment, the an environmental impact statement if one is required, or environmental documentation, all the findings related to our thresholds. It is an intense planning effort. What the states decided is that if we were going to do one of those in the future, within the next 4 years, that it wouldn't require, in addition, a 208 plan amendment, but it requires a regional plan amendment, and perhaps, you know, I'm not an expert to say what sort of permitting requirements from the Lahontan region, if it's in California, but that is the genesis of that one provision in the 208 plan, which is essentially to say if there's one more resort recreation designation, you don't need to come for a 208 plan change, but if there's more than that, then you do. So we actually see it as a limitation, another limitation on when TRPA needs to do a regional, excuse me, a 208 plan change, because for no other land use designation change is there a requirement for a 208 plan amendment, just for this one particular one. So there's one that's allowed without a 208 plan change, and then any other more, or any addition, we've got to come in for a 208 plan change. So hopefully that kind of clarifies. There's not an approval of a ski resort. It may be that there are areas in the basin that are looking, that maybe want that designation because it allows the concentration of, again, kind of the transfer of existing development to these other areas, but they'll have to go through the whole gamut of planning to get that.
Right. Okay.
Does that?
Question?
Well, I had some, not on that issue, but other questions of staff.
No, go ahead.
Okay, so maybe just to make it a little more real for me, because I'm a new member here, on the issue is in follow-up to Chair Marcus's questions about other processes. If you could just take an issue that was raised by the Sierra Club on pervious surfaces. And because, as she said, there's nothing in the plan, could you point us in the direction as to other plans where there might be more detail with respect to that issue, and what process is in place so that if more science is developed, there could be adaptive management strategies or a process to make changes and add additional requirements?
I think there's a couple different levels of planning that would apply to that particular issue. Each of the local governments are required to develop what are known as load reduction plans. So they have to present to the regional board their plan for the upcoming 5 years, how they expect to achieve their load reduction requirements. And within the context of that plan, as Board Member Moore referenced, they're required to use the Lake Clarity Crediting Program to demonstrate how those proposed actions are going to improve or otherwise change water quality. Within the Lake Clarity Crediting Program, there are a number of quantitative tools that are used. Within those quantitative tools, there are individual BMPs, which is the level of permeable pavement, or pervious concrete, either way. So
Well, you're going to do a little contest to see which word is
see which
best
one
to
works
use
best.
over time.
And that's exactly
Easier
what
to
happened,
say.
frankly.
Yeah.
So if we're looking at whether one of those different BMPs, so first we would look at how does the quantification tool handle that particular BMP. And if it does not, well, then there may be a need to apply some additional monitoring, research, or other information, or perhaps we look at Seattle or other areas that have done this to provide us with a starting place. We expect that pervious pavement is going to provide us X amount of benefit. It is going to infiltrate water at, 1 inch per hour, or whatever it might be. So we can use that as a starting place. But because of the uncertainty, as Ms. Ames indicated, of how these things may function in an alpine environment like ours, we would require some additional monitoring on that particular product to determine whether or not that assumption of performance is consistent with our expectation. That would then influence change over time. The next jurisdiction that brings forward a project that includes that particular BMP would then be required to use the most up-to-date information. That information would then, again, translate to another scale of planning in the TRPA BMP handbook. Again, the BMP handbook provides, at this point, the most up-to-date information we have on design standards and how BMPs are implemented. It's not recreating the wheel, so again, if there's a great deal of information about how to design and implement a permeable pavement surface, they will simply bring that information in. If we learn additional information from our monitoring exercise on the effectiveness of that in the Tahoe Basin, then not only would it influence future jurisdictions' actions under the Lake Clarity Crediting Program and the associated quantification tools, but it would also likely lead to a change of the TRPA BMP handbook, providing that information to different users as to how to implement that particular product on the ground.
That's helpful. Thank you.
Can I add one clarification? What TRPA did, if this is focused on TRPA's regulation regarding pervious pavement, it's just that TRPA provided 25% credit under its coverage rules for pervious pavement, even though infiltration is greater than 25%. It's part of our BMP handbook. It's not, as unfortunately Laurel is incorrect, there is a number of pages that describe pervious pavement and its requirements. There's also a requirement for redundant BMPs. We have a segment of pervious pavement in our parking lot that we have monitored and in fact have noted probably because of its location, has not, without any regular sweeping, it has maintained its level of permeability. Permeability.
I like permeosity.
There we
though.
go.
Have a motion to include that as a word? Yeah.
So it's not quite the situation as described by the Sierra Club.
The issue that Ms. Ames mentioned about the 100% credit versus 30 or coverage, and would it be upstream or downstream of wherever the water body is that something that you can answer? Okay.
Yes.
Would you?
What she's talking about is a device within the area planning concept that's called a comprehensive coverage management plan. And so if a local jurisdiction wants to recommend to TRPA has to adopt these, a comprehensive coverage management plan for a discrete area, it can do so. And what that means is instead of managing coverage on a parcel by parcel basis, which is now generally how our regulations apply, they can manage it on a little greater scale. All right. So what that means is if you want to essentially it's a tool to try to promote environmental redevelopment.
Right.
It gets, because right now, if you, like I said, on the South Shore, you have lots of individual parcels that are kind of locked in given their existing development, and it's almost a response to the grandfathering that we do for existing overcovered lots. So what we want to do is say, okay, local government, if you can figure out a way to get the same benefit, you can't in any way harm the environment from what you do, but what you can do is look at coverage and manage it on a larger than a parcel level. So yes, it allows you to, depending on how you define 100% of what, right? Right now we have lots of parcels that are covered 100%, but this allows them to manage that within a greater area than just one parcel, but only if they can demonstrate that there is no net harm as a result of such management, that there's actually reduction in sensitive coverage or in sensitive lands, and that they go through all the environmental documentation requirements and prove to TRPA that there's a list of findings that have to be made for these comprehensive coverage areas. So it's a way basically of saying, all right, because parcel size varies, so you can apply 70% coverage on one parcel that's this big and have that same coverage move over to another parcel that is this big, and the reduction goes down, or 100% coverage on this parcel and it's only 20% on a larger parcel. So the parcel definition is somewhat arbitrary in the sense that if you want to be able to manage, let's say, a development strip rather than 6 parcels or 8, 10 parcels, you can do that under this system, but there's tight regulatory controls to establish that it must be as good as the current system, and you have to have these environmental benefits of showing a reduction in sensitive land coverage.
That's what I thought.
It's kind of like that Los Angeles example, you know, a couple months ago. You know, I mean, it's the same concepts.
Maybe more so.
Yeah, maybe more so.
If
yeah.
you want multiple pages of regulations, we have that, if you want us to show it to you.
We're trying not to do things by the word anymore,
Right.
just so you know. Anything, Dan?
I just have one question, and it's a bit digging into the weeds. So, Mr. Larson, in looking through Ms. Ames' letter, the one comment that I couldn't find a response to, and it may just be buried and I can't find it, is her comment that the regional plan updates baseline conditions are not consistent with the TMDL.
I don't know that the regional plan has a baseline condition that it would be referenced, and maybe Mr. Marshall can address that concern, but the TMDL does establish a baseline of the water year 2004. All of the NPDES regulations and all the different quantification tools that I've been referencing all use the conditions as of 2004 as our baseline.
And perhaps Ms. Ames can clarify, because her concern is that that's not consistent with whatever is in the regional plan updates.
I can say that we worked closely with TRPA staff to explicitly ensure that the water quality components of the regional plan were consistent with the TMDL, so I would appreciate that clarification as well.
Please, Ms. Ames?
Yes, I think that was actually their statement and their reason for amending the, putting together the new amendment. And I'm a little confused, but I'm confused.
Okay, well, I'm reading from your letter in your summary of concerns.
Our summary?
Yep.
Well,
I guess we're all
can't answer
confused then.
you because I just don't know.
I'll take a look.
Wait a minute. Do you know where it is, John?
I don't know.
It's on it's on page 2, and it's where it says summary of concerns, and that's Roman numeral 4.
Okay, let me see.
And I believe the staff very adequately addressed the concerns 1, 2, and 3, but I didn't see a response to 4, which is where that sentence about baseline condition comes in.
Oh, it refers back, not to the statement, the first sentence. That just says what's in the 208 plan amendments. And then it says, our concerns regarding effectiveness have not been addressed.
Then it says further, the RPU's baseline conditions do not comport with the assumptions used in the TMDL.
Oh, that gets into a whole other weeds.
Okay, definitely
I'll be
weeds.
glad to have a conversation with you about it, but it's very weedy.
Okay.
Thank you.
I think there's one thing that I would like to mention.
Please.
And that is that the assumptions used in the TMDL regarding the essential development capacities that TRPA approved in the regional plan update are consistent.
Are consistent. Excellent. Thank you.
Okay. Further questions? Comments? Motions? Seconds? New words?
Well, I think Fran and I, the old timers on the board, were here when the TMDL was brought to us for consideration, and I remember being briefed by Lahontan Regional Board staff and thought it was one of the most comprehensive, well-done briefings. Actually, it was, I think, one of the first briefings we had where we made the switch from state board staff bringing the TMDLs to the state board to regional board staff bringing the TMDL to the board. And I remember thinking at the time, very envious of the science and the research efforts that are going on in the region, and also very impressed by the commitment from the board as well as from staff in undertaking this very complicated TMDL and addressing the very complicated issue. So while I am sensitive that concerns remain, that challenges remain, I believe then, and I continue to believe now, that this approach will provide us with the best opportunity to gather the information, to put in place the activities, the actions, future regulatory activities for future TMDL's improvements that will result in meaningful water quality contributions and improvements in the lake. I appreciate the collaborative process that's been so important to this effort, and I also very much appreciate the environmental organization's input, which I know has made this a better effort and will continue to improve this whole process as it moves forward. So I will congratulate once again the staff on your outstanding work on this matter, and I will move for adoption of this item.
Second?
Before we vote, I want to thank everybody for the time that they've spent on it, including the environmental community. I know that in change like this, there are things to worry about. I also have to say that much of what these folks are trying to do are the kinds of things we're going to need to be doing in terms of encouraging, using redevelopment to improve things, since the existing development is a huge problem at the lake. And I know a lot of folks in these agencies, the Conservancy and others, are really sort of trying to figure out a way to accelerate the move away from the existing format to a new one. And so in trying new things, including adaptive management, which is coming up in many of our programs now, there's a certain amount of fluidity, flexibility, and yet the need to watch it like a hawk and to quantify results. And I do think it requires more oversight and watching. I'm fairly, I think 5 years is not a hugely long time in the scale of what we're doing, but nothing stops us from having regular updates on how it's going. And I would ask that we come back, if not every year, at least every other year, so we have a couple of chances. I'd ask the Lahontan, that'd be a recommendation, that Lahontan and Turpa come back in open session. People can tell us how it's going. Just in general, on a host of fronts, I just think we're interested enough in Tahoe that we're going to want to do that. So I think we can just calendar those kinds of updates, because we're going to have to be doing that in the stormwater context and a lot of other contexts where we're doing more fluid and multifaceted efforts than in the more strict, everything's laid out in a reg format that we did in the early days. So hopefully we'll be seeing a lot of all of you without any ado. But I do think that a lot of thought has gone into this, which I appreciate. And I do get the sense now that there are safeguards in case something within those 5 years looks awfully wrong, that folks have recourse to come back in a number of forums. So I don't think we're signing away all too much in this process. So. Great.
Just Lahontan Board would be very pleased to come back every year and give the State Board an update on our progress on the TMDL and other activities and the co-benefits we get from this RPU to deal with issues we can't, like some of the air deposition requires transportation changes, and so the partnership is very important, so we would be happy to come back.
Great. Thank you. All right, we have a motion and a second. All in favor?
Aye.
Aye.
All opposed? Okay, carries. Thank you all very much. We'll now take a 15-minute break before proceeding to our last two items, so come back at 10 after 11.
a lot of them in there. But I don't, obviously, there's resources. I definitely believe in the process. Really, the whole way the state is set up to interact. Oh, we have our Clean Water Act talk in stormwater cases. A couple of so that's chugging along. Bunch of yeah, it's kind of interesting when the unions are so much more powerful than our other clients. They're just so much, they don't have to say anything. And what we have, what else is happening right now? This week.